Hi everyone, welcome. I'm Annabelle Baldi from BioBuzz. I'm super happy to have you guys all here for another one of our Career Catalyst sessions. Some of you may remember and have joined us last time when we had Lisa Madovic on during a session a couple months ago. Today, she's going to be sharing her journey bridging science and law, and is going to give us an inside look at the role of intellectual property in biotech and pharma. On that side of things. So we're thrilled to have her back with us today. A little bit about Lisa. Lisa has built an impressive career as an intellectual property strategist, shaping global patent strategies at companies like Novartis and GSK, following her early legal work at Finnegan. But before moving into IP, she led a cell biology lab at Yale. So that gave her a unique perspective as both a scientist and attorney, and led her into patent law. But beyond her professional work, I do want to mention that Lisa also serves as co-vice chair of the MAPS Committee for Women in Bio Capital Region chapter, where she's very passionate about mentoring and advancing opportunities for others. So great to have her on today to help further that partnership that we have at BioBuzz with Women in Bio, that Capital Region chapter. And like I said, Lisa today is going to dive deeper into diverse career paths in IP. So looking at kind of the patent agents to technical specialists, and looking at how you're able to shape your scientific background and how that can give you an edge in this field. Before I do hand it over to Lisa, I do want to give a quick thank you to BioTrack, our sponsor for today's session. So I want to thank them for sponsoring. BioTrack has trained over 17,000 scientists through their advanced biotech workshops. I would highly recommend checking them out if you're interested in upskilling. You can check them out at biotrack.com. And also want to mention that today's event is part of the BioBuzz Talent Lab. So that's your hub for career growth, opportunities, and industry connections. If you haven't already joined, I would definitely check us out. You'll be able to find more opportunities like this. All right, so I'm going to hand it over to Lisa.
Thanks, Annabelle. Can everyone hear me? Am I on mic?
Getting some thumbs up. Perfect.
Okay, great. Yeah, thanks for that great introduction. And especially thanks for calling out Women in Bio and the mentorship. And I just want to say that after this presentation, if anybody wants to get in touch with me by LinkedIn or just have a conversation about intellectual property law, I am utterly delighted to do that. So don't hesitate. So let's dive into this. Today, we're going to talk about intellectual property. And what I'd like to do, as Annabelle said, is first of all, I'd like to talk about intellectual property, especially patents, really only about patents. And then connect patents with science, because they are intimately and integrally connected. And then let's go into careers in intellectual property, discuss the options, and that I think will lead us directly into what I hope is a robust discussion about intellectual property, law, careers, et cetera, et cetera. So let's jump in. What is intellectual property anyway? Definition is intangible creations of the human intellect. Well, that sounds fuzzy to me. So what is it in real life? What are the tangible outputs of these intangible creations? They are patents, trademarks, copyrights, and trade secrets. Patents, we're going to spend the rest of the presentation talking about. Trademarks are brand identifiers. When you see those golden arches, you immediately know what brand of fast food is identified with it. That's a trademark. Copyrights are attached to documents. For example, books. You can't just take a chapter of a book and claim it as your own, reprint it, and say you wrote it and take credit for it. That's copyright law. Trade secrets cover confidential business information. Many of you know that the formula for Coca-Cola has been known for many years. It is not patented because patents typically run out of protection after about 20 years. And the Coca-Cola folks said, we want to keep this for a much longer time. And maybe it isn't patentable anyway, so we're just going to keep it as a trade secret Only a very small handful of people know what's actually in Coca-Cola. And so it's a trade secret, confidential business information, not patented. So that's the that's the broad range of intellectual property. My specialization has been in patents. And honestly, most intellectual property attorneys are focused on patents, and intellectual property careers in general are focused on patents, although many are specialized in trademarks as well. So let's talk about patents. Let's go for the basics. What is a patent? It is a form of intellectual property protection, just as we just said. It is a legal document. It is a legal protection. It's awarded by a government for an invention. When I say awarded by a government, I mean, for example, if you have a patent in the United States, that patent protects your invention in the United States. You can't practice that patent in another country unless you actually have a patent granted by that country. And I wasn't planning on going into a lot of detail about how that works in this presentation, although I'm perfectly happy to go into that in as much gory detail as anybody wants. The characteristic of a patent is that it's a negative right. And by negative right, I mean that the patent owner has the right to prevent others from making, using, or selling whatever is in the patent claimed invention. And I'll give you an example of a practical implication of a negative right. Say you've invented, excuse me, say you've invented a protein vaccine, and you would like to commercialize and use this patent, this protein vaccine to prevent X disease in so many people. Well, perhaps this vaccine requires an adjuvant to be sufficiently efficient. Now, if you have the patent to the protein vaccine, but you do not have the patent to the adjuvant, you can do whatever you want with your protein vaccine, as long as it's claimed in the patent, but you can't use the adjuvanted vaccine unless you have some kind of agreement, or you've purchased, or somehow you have rights to the adjuvant as well. So by negative right, you have the patent owner has the right to prevent others from making, using, or selling the claimed invention. Whoever has the adjuvant patent can prevent whoever has the protein vaccine from exercising, as we say, the adjuvanted vaccine. So the patent protects what is claimed in the patent itself. Typically, patents last for 20 years from the date they're filed. This can be extended under certain circumstances, regulatory circumstances, delays by the patent office, et cetera, et cetera. But in general, if you estimate your patent's going to last about 20 years, you're going to be accurate. Yeah, and I'll just say, just to close up the thought on that slide, the patent is a deal. It's a deal with the government that if you disclose your invention to the public and you share that, you get exclusive rights to it for a limited period of time. That's the essence of patent law. So I want a patent. How do I get a patent? Make an invention. Must keep it confidential until it is filed with the patent office. And the way you do that is to draft and file an application that fully discloses the invention. This is typically done through a patent attorney or a patent agent in close collaboration with the inventor or the inventors. Then, once it's filed, you have to convince the patent office in every geographic area that you want to have patent protection that this invention is actually worthy of a patent. Well, what makes it worthy? What makes an invention patentable? It has to be novel. and by novel, it must be new. If the thing was publicly available before the application was filed, it's not new. If you have an idea for how to treat diabetes with magnolia flowers, you think, wow, nobody's ever thought of this before, it must be new. But if there was a paper that was published at some point that says, we have treated diabetes with magnolia flowers, then that destroys the novelty just by it being a publication. And the kinds, I know that's an extreme example, but you can see how that can apply very easily to actual inventions, whether they be things or treatments, and we'll get into that in the next slide or two or three. But anyway, the types of, and we call them prior art, that can defeat the novelty of a patent application are scientific papers, articles that have been published, posters that have been presented. These have been documented as being prior art by people who have taken pictures of them at conferences, press releases. Oh my goodness. Okay, short anecdote. When I was working for Big Pharma, we had a brand new way of using one of our drugs, let's just say one of our drugs, for treating a disease that nobody had ever thought of treating this disease before. And we had data. The scientists had really nice preclinical proof that this was working to prevent and alleviate this particular disease. Well, there was a conference, and one of the very high corporate officials said to the press, "We are working on using this drug to treat this disease." Well, the patent application hadn't been filed yet. That completely destroyed the ability of our company to commercialize this drug for this indication. And it could have been used for millions of people to treat a disease, but without patent protection, there's no possible commercial case for pursuing it. So we lost that just because a very high-level corporate executive talked about it before the patent was filed. So keeping novelty is something that keeps patent attorneys and patent professionals up at night. Oral presentations can defeat novelty. They can be recorded, their notes can be taken, et cetera, et cetera. So yeah, an invention is patentable when it is novel. It's not patentable if it's not novel. The second big criteria is that it has to be inventive. It can't be obvious to someone who works in the field that, of course you would do that. That's just not inventive. Anybody who works in this particular field, in this particular area, would just know that you would do this. It's not inventive. It's obvious. The term of art is obviousness. Term of art in the United States is obviousness. Term of art in Europe is inventiveness. Whatever. Same thing. Now, with certain legal qualifications to that. But anyway. And finally, it has to be useful. Now, biotech and pharmaceutical inventions are considered to be useful. This is rarely, if ever, and I think I'm going to go out on a limb and say that biotech and pharmaceutical inventions are never considered not to be useful. When I was in law school and the professor gave an example of an invention which truly was novel and truly was inventive, but was not useful, was having an orbiting cat litter box that orbited the Earth all by itself, just the cat litter box. Not useful, but that's pretty extreme, and we don't have to think about that in the realm of biotech and pharmaceutical inventions. Let's go on. Concrete examples of biotech patents. Physical things, we call them compositions of matter in the patent world. Physical things that you could touch. Well, maybe if your hands were small enough. Things like antibodies, vectors, hybridomas, genetically modified organisms, things, concrete things. Also, combinations of things. You can combine an antibody with a radioligand. Maybe the antibody was no longer novel or was obvious. Maybe the radioligand wasn't novel. It was known in the art. But certain ways of combining the antibody with the radioligand or certain methods of using it could very, very well be very, very well be patentable. Things like vaccines, things like fixed dose combinations. When you put just two drugs together, and I'm trying to think of what's in Excedrin, for example. I think it's caffeine and something else. I can't remember. But anyway, when you stick two things together in a certain dose and it's never been done before, and you show that it does something inventive and new, then that's patentable. Formulations are definitely patentable. What you put your drug in can be the combination of that drug in certain formulations, like buffers that support stability, buffers that support thermo stability, formulations in different combinations, definitely patentable. Methods of use of your thing, methods of treating disease disease X with compound Y, very patentable, very useful in the field of biotech and pharmaceuticals. Processes, the way you manufacture a drug, the way you manufacture a combination or a composition or a formula, even a formulation. Manufacturing processes, they're often patentable. They're often patented. They're sometimes kept as trade secrets. Sometimes they're not inventive and they're obvious, but they're not. They're considered confidential information. Manufacturing processes, purification, things along those lines. Think about as potential patentable opportunities. And finally, I'll mention that administration routes are something that is very commonly patented in biotech and pharma. The method of giving the drug, whether you can include IV administration, perhaps in a method of use patent. You can create an entire patent around a particular prime boost vaccine regimen if you show that this particular dose, giving a primer at a certain dose, at a certain time, at a certain interval, before a boost or 2 or 3 or 4 or whatever, of a certain dose at a certain time, at a certain interval, very patentable. Regimens are patentable. Specific treatment schedules can be patentable. And again, it all comes back to, are they novel? Are they inventive? Are they not obvious to someone in the field? So these are examples of the broad range of patents that we in the biotech and pharmaceutical patent field are dealing with. This is our bread and butter. This is what we do. Now, it's all about the science. The patent attorney does the patent work, writes the patents, gets the patents through the patent office. The patent attorney is working typically with a lot of different fields. For example, when I was in pharmaceutical companies, it would be not uncommon for me to be working on a platform of what can I say? Let's just call it a platform of vectors that can be applicable to 5 or 6 or 7 different diseases. So that's a broad range of stuff to know and to think about. And as patent attorneys, we haven't typically, some of us, I have colleagues that have gone to medical school. A lot of us have PhDs in science, more and more every decade, I would say. But communicating and understanding the science is utterly critical to good patent practice. The patent attorney, the patent people, the patent department, and the research and development teams must work together to effectively protect the invention. You have to align your objectives. If R&D wants to go after something that no way, no how is ever going to get a patent, is ever going to be protectable, is ever going to be commercially useful, the company is not going to want to put its time, effort, and millions and realistically billions of dollars into this. And it's up to the patent professional to align and create the proper expectations and realistic expectations of what can happen. So to do that, and the patent attorney has to understand the science. If the patent, I keep saying attorney because I'm an attorney, and that's the way I think. It doesn't have to be an attorney. It can be, we'll get into this later. It can be an agent, it can be a tech spec, it can be lots of different things. But the patent professional and the scientific project people have to talk and have to understand each other. In my experience, we have always met regularly. I have attended all of the project meetings of the projects that I have been intertwined with. Fortunately, that meant going to Rome 2 or 3 times a year to talk to my team there, which was wonderful. Or it can just mean sitting in a Zoom meeting once a week to see what's been happening with the research and development team. When I was at Novartis, the patent attorneys and the scientific project leaders met quarterly, and we talked about what research is going on, how the filed patents are progressing through the various patent offices, what's been happening, what plans are we making for the future. We always had a legal team in there to make sure that things were properly contracted with any other entities that we may be working with. We always included business development in case we were looking to collaborate with a different company, or in big pharma, we would be very active in business development when we were considering acquiring another company to beef up or complement a portfolio that we might have. So it's all about talking to everybody. I'm going to spend just a little bit of time here because I think it's important. As a patent professional, I would work with communications teams to make sure that our objectives were always aligned and that what they were talking about was what we were actually doing. No, I'm sorry, Annabelle. I'm going to stay on the last slide for a little bit. And I would work with clinicians very, very closely just to understand the diseases and the disorders from a clinical point of view so that I could write method patents. How do you write a method of curing X disease with Y drug if you don't understand the disease? I would work very closely with regulatory folks who were getting the getting the drugs through FDA. You have to align what is actually in the patent with what is in the product label that is going to come out when the drug gets on the market. Because if you're not protecting what is actually the drug and how it's being used, then you don't have full protection. So you really need close collaboration with regulatory people. And like I said, I'd work closely with business development people. We would evaluate potential business partners and acquisitions. We would do due diligence on potential acquisitions. That was really fun. But yeah, I think that's all. Yeah, that's all I want to say about patents and R&D working together. And it's not just R&D. It's almost every part of the biotech or commercial enterprise. We, as patent attorneys, were so often able to give input on other areas because we were, in some ways, the glia that was connecting all of the different areas of the company. When I was with Novartis, we did an introductory team building thing where all the new people would go to headquarters in Basel, and we would do a little board game where we'd play a little board game. The bottom line was the patent attorneys always won because we were the ones who knew what everybody else was doing. But anyway, I'm yammering on and on. Let's go to the next slide and talk about how it all starts with good science. It all starts with good science. Patent law, patent practice is so closely integrated with science. Research has new ideas. They generate new data. Maybe they have a new antibody. Maybe they're characterizing a new antibody or protein structures, or they're developing new assays or improved assays. They're developing formulations to use these things. They're thinking from the get-go about what clinical applications, what clinical outcomes. They're thinking about safety profiles. They're thinking about biomarkers. And someone from intellectual property is always going to be involved in this, reviewing it to what is known, comparing it to the prior art, evaluating patentability as we go along. The IP folks are determining what can be patentable. Remember, what's patentable, novel, non-obvious over the prior art, what's already out there, and they're devising the strategies about how to create a patent portfolio with all of the different aspects that I've told you about. A patent application devoted to the thing, to the methods of using it, to the formulation around it, to the dosing and administration regimens, the portfolio that is protecting this invention. We draft and file the patent applications. We review the proposed research publications because researchers want to publish. Of course they do. Companies want to get their wonderful inventions. They want to tell the world what they're doing. They give posters, they give presentations, they write manuscripts. We need to ensure that all the contents are covered by the patent filings before they publish. That can put a lot of pressure on a patent professional to get this stuff filed before the company gives the poster. I don't even want to think about how many times at a small biotech I was told on a Friday that an inventor is on a plane and about to give a poster that I haven't seen to. Anyway, that's just part of the job. So, but it all starts with good science. That's my message. It all starts with good science. Let's transition into the last part of the talk. And I think this is what is going to transition into what I hope will be a robust discussion. Have I talked too long? Can you assure me that we're going till 1 o'clock and not 12:45, or are we scheduled to end at 12:45?
Yeah, no worries. We'll run a little bit over, but you're good. You're good on time.
Okay. Options for careers in intellectual property. You can be an attorney. You can get a law degree. It takes 3 years, and then you pass the patent bar. When you do that, you can work for a law firm. Almost always you need law firm experience before a pharmaceutical or a biotech company will hire you. You can go into solo practice, hire out, hang out your shingle and do your patent work. You handle all aspects of intellectual property, including a lot of contractual work. You do the prosecution work, which means getting the patent granted, and typically you specialize in one or the other. I was a prosecution attorney, or you can specialize in litigation, defending patents that have been challenged in courts. You interact, like I said, with research, with clinical, with regulatory, with commercial, with business development. You do not need to be an attorney to be a patent professional. You can be a patent agent. Patent agents have to pass the patent bar, which is not easy. I've done it. Typically, patent agents are patent prosecution specialists. They write patent applications. They obtain patent grants through the patent office. Typically, work with attorneys who are doing some other work with the product itself. I have worked with patent agents who have been utterly excellent experts in the patent law. I worked with this one guy who had been doing this for 30 years. He knew everybody at the patent office. He could just call up somebody and get whatever he needed to know to get stuff through. Just brilliant, because when all you do is prosecution, you are a specialist and you really, really know prosecution. Without passing the patent bar, you can be a technical specialist. You can directly apply your scientific knowledge and expertise to patent law. Now, this is typically done within a law firm. Someone who is an expert in a particular field can go to a law firm and be the person who will be the liaison between the inventors who are not in the law firm, who are clients and who are developing the work, and the attorneys who are in the law firm, but not necessarily experts in the particular scientific field. So you're the translator, and you're doing a lot. You're actually doing a lot of the drafting and a lot of the understanding and determining what is patentable and looking for the prior art. You're communicating with the scientists, you're analyzing the invention for patentability, you're performing the literature searches, and you're evaluating patentability because you're the one that understands the science. And the beauty of this is that if you go into a law firm as a technical specialist, many law firms will pay for you to go to law school at night. So this is an option. If you want to go to law school at night, now you kind of give up your life because you're working, 40 hours a week, and then you leave the firm, and then you go to law school at night. But it's a path, and it's a path that many people take. There are more options. You can be a licensing specialist. This person is someone who evaluates patent licensing opportunities, negotiates contract terms, monitors compliance with licenses. This can be someone within a company. This can be someone with an independent practice, for example, a consultant. But licensing specialist is something that is related to patents. You can do technology transfer, something I probably know the least about, so I'm going to be really careful about what I talk about. And if anybody here knows more about it than me, I would appreciate that. Universities have technology transfer offices. They support startups that are happening with the academics. Maybe a faculty member wants to spin off a company. They get tech transfer support within the technology transfer department. Another option is to be a paralegal. To become a paralegal, you do certain coursework and you get certified. There are many, many options for specialization. You obviously don't have to be a patent paralegal. You can be a patent paralegal. And when you do this, you support patent functions, and this is often done in law firms, although certainly pharmaceutical companies hire patent paralegals, and I can tell you that mine were invaluable. And just I can't say enough about my patent paralegals. I leaned on them heavily, worked with them, loved them to death. One of them knitted me a scarf when I left. Anyway, docketing specialists and support staff. These are people who are usually within law firms. They use software. They keep track of the patent filings. This is like being a project manager in a sense. You keep track of due dates. You keep track of patent filings. And you bug people to make sure that all deadlines get met. Because if a patent deadline gets met, it's almost never repairable, and billions of dollars can be lost when a patent deadline is not met. So all of these options available, wonderful. I hope I've given you a taste of what patent law looks like, and at this point I would like to open it up to discussion, questions, comments, whatever.